Hi, everyone. Hope you can hear me. Sorry it took me an extra minute or two to jump on today. So, welcome to Facebook Live Friday, September 17th. And as always, just post your questions. If anybody has any questions that you want to ask, no problem. I'm just going to talk about the usual latest immigration updates, what's going on, answering any questions. And so I'll just start out the day by letting everyone know I had a great case this morning. Things are going typically much better in immigration court, not across the board, but I had a nice, quick grant of adjustment of status, so a green card application for a client that I've had and have been representing for the last 13 years now. We decided this morning when we were chatting, we forgot how long it's actually been. So that was awesome. There was no pushback from the government. Everything went smoothly. The judge was happy to grant the application, and we were out of there in 15, 20 minutes. So it was an awesome morning. So hopefully things will continue along that trend. I really feel the judges in a lot of cases are more fair. Things are more reasonable in Atlanta. Not always, but we're starting to see some signs of some improvements and just better treatment from the court and from some of the government attorneys, not all of them. So it's a nice trend that seems to be hopefully picking up and will continue. So I think really what I want to talk about is some of the things that are going on in court in case some of you aren't familiar. So anybody who's in immigration removal proceedings right now, with court dates scheduled, not scheduled, pending, have been in court for years or even just in the last year or two, there have been lots and lots of changes, primarily because the Department of Homeland Security, which are the government attorneys, they are the prosecutors representing the government, they have been given orders and guidelines to follow to be able to go through and review all of the cases that all the active cases that they have right now to determine what cases they think would be good candidates for dismissal completely out of court. And dismissal means that your case would be terminated completely. You would not go back to court. That will typically happen when an individual is eligible to file for a green card with USCIS or file for some other type of relief, similar relief with USCIS. And therefore, it's a good case where they don't feel that it's important or that they have to prosecute the case in court. So all of this is being done in an effort really to try to clear up the significant backlog that built up with the court, in particular over the last 4 to 5 years and even before that. And so, that's really part of that effort. And then, so there are other options as well. Basically, everything is in this overall governed by this umbrella called a PD request or a prosecutorial discretion request. And those PD requests, from what I understand from the government attorneys and speaking to them, can take any form. And so, for instance, if I have a case where I feel it's a strong application, it's worthy of a grant, rather than showing up the day of and expecting to litigate the full case, which very well may still happen, but there's nothing that says that I can't write to the government attorneys in advance and in the form of a PD request actually ask if they would consider a grant of relief, meaning actually agreeing with us to grant the actual application itself. So that's one other option. In some of these cases where I'm considering PD requests, I'm first asking them to consider a grant of relief. And in the alternative, if it's not something that they're going to agree to, then I'm either asking them to join in a dismissal of the case so that we can pursue the green card before USCIS, or even alternatively, in some cases where we have applications pending in court, where it's not a very strong application, but the person is able to get a work card and keep renewing their work card, then I would make a request for what's called administrative closure. That also applies in a case where somebody might be eligible for a green card but has to process from outside of the United States. Well, for the last 4 years or so, we haven't been able to process those cases very easily because of a certain case or a certain decision that was issued, I want to say back in 2018, that was just recently rescinded. So it went from being a very difficult process to, again, being a bit easier, where somebody can apply for a green card and process from outside the U.S. We can again resume our efforts to seek administrative closure for that person to then be able to file the necessary waiver, get that waiver approved, and then get out of court permanently, and then be able to travel to attend their green card interview abroad. So that's, again, those options have again resumed, which just gives us a really great opportunity to, again, clean up a lot of these cases that have been really stagnant over the last few years because it's taking so long in order to complete the processing of anything, with court delays and even consular delays at this point. So I do see a question that popped up. I always typically get lots and lots of questions on DV 2020 litigation. I don't personally have any information or status updates in terms of Meta's final judgment. And of course, typically we can't know exactly when a judge is going to issue a decision on a case. So I wouldn't be able to predict that for you anyhow. So we will have to wait, but of course, continue to follow the Impact Litigation's weekly Facebook Live updates. That's going to be the best way for you to be able to kind of get the latest information. I won't be able to give that to you personally. So I see another question. How long has it taken to get a citizenship appointment after acceptance of the application? So great question. Applications right now that call for in-person interviews, like a citizenship application, it is a bit all over the place in that if you look at posted processing times, they may say one thing like 18 months or 24 months in some cases. But the reality is for a while before COVID, we were seeing citizenship applications get scheduled sometimes like 3 months after they were filed. And the general trends that I always see over the years is that citizenship applications filed in the summertime leading into the fall tend to process much faster than at any other time of the year. I think it's because they typically go through, auditing and trying to get decisions in before the end of the fiscal year for their numbers and things like that. So, but if I had to say on average right now, 10 months or so, 10, 12 months. I've seen some get scheduled in 8 or 9 months. So I'm going to probably throw out there about 10 to 12 months from the point that you get a receipt notice that is filed until the point that you get scheduled for your interview. So I hope that's helpful for you, and it's not going to be too much longer for you. Filed end of September 2020. Okay. So, sometimes that might fall into, unfortunately, what's happened with COVID and just having staffing issues, interview issues, things where local interviews are required, and if there's COVID issues and things like that. So I would certainly suggest maybe following up, writing to them, to do an inquiry, sometimes opening a congressional inquiry, like reach out to your local representative, see if they can help. And sometimes I'll be honest with you, to the person who's asking this, you can do all of those things and still not get anything and wonder what's going on. There's probably nothing wrong with the application. It's just sitting in a giant pile of a bunch of other files and applications also waiting to get scheduled for an interview. So this is where one thing comes up that I do quite a bit is, so I direct our federal court litigation practice here at the office, which means we get to sue immigration lots and lots over delayed cases and applications that should have already been scheduled for an interview but haven't. And so we file litigation. We don't have to worry about retaliation. That's the first question I usually get asked. Immigration does not take it personally. They don't care. They just rather not deal with the litigation. So if it's a clean case, if there's no eligibility issues, those are all the questions I ask. Then one of the next steps I typically offer or suggest, only if somebody is really tired of waiting, they've done everything else they can, they have no other options, and they decide, okay, let's go ahead and sue them. So that's something I do quite often, especially in this local Atlanta district. And normally that produces results within about 90 to 120 days or so and gets everything taken care of. So it can be a really good option. But again, it's, in terms of legal fees and things like that, you're obviously looking at something more than just, let's say, sending an inquiry. But you kind of start looking at that possibility when you're just tired of waiting and you're not seeing any movement. So if you ever need any help, just feel free to reach out to me. So what I want to talk about is the proposed reconciliation bill, which includes in it, if you've heard anything about it or saw anything in the papers or anything like that on the internet, the reconciliation bill has a significant component to it for immigration, for provisions for immigration. So which would be really, really awesome awesome. And it's something that we will probably know within the next week and a half or two as to whether there is a possibility it's going to get signed and it will go into effect between, now, but pushing out 6 months from now type of thing. So it actually basically covers 4 categories of individuals who may be able to, if it passes, who may be able to seek a permanent path to status in the U.S., which would be incredible. So just get ready. If this does pass, it will get super busy. You'll have lots of questions. We'll be getting a lot of calls, and hopefully we'll be able to help a lot of people. So generally the 4 categories are DACA recipients. Okay, so this would be finally a path like the DREAM Act, and it would lead to permanent status and green cards for those who currently hold DACA status. So there's a whole bunch of different criteria that go along with it. Obviously, anybody who currently has DACA will likely end up being eligible, even if they had to complete a couple more requirements for this particular provision written into this reconciliation bill. So another significant category that was included in the bill are what's called essential workers. So there's apparently a whole list and wide variety of what is considered an essential worker. It's very broad. So it actually can help potentially many, many individuals in the U.S. And then the third category is TPS holders. So individuals who currently have TPS, and finally also DED. So TPS, again, temporary protected status, all of you whom, Honduras, El Salvador, Haiti, just Venezuela, several different countries who currently have TPS. This certainly may be an excellent option going forward if it passes, providing you a pathway, other than some of the very difficult pathways and some that are a bit easier when you've traveled on advanced parole and you re-enter the U.S. lawfully with that parole document and you have a family member who's petitioning for you. But there have been, of course, a lot of complications for TPS holders who have prior removal orders. There's a lot of back and forth with the court and decisions coming out of USCIS. So if this reconciliation bill passes, this provides a much clearer pathway for TPS holders to be able to seek permanent residence. So again, it would be amazing. And finally, for individuals less commonly, but who may hold DED, which is deferred enforced departure. It's sort of similar, but an alternative version of TPS. Oftentimes it's something that's implemented upon, let's say, the termination or the ending of TPS. Things sometimes move into what's called deferred enforced departure. So it's another category, again, that may help an individual be able to pursue lawful permanent residence status in the U.S., again, if this reconciliation bill passes. So we will know soon enough. Obviously, you'll be hearing a lot about it if it does pass. I'm not going to get my hopes up too much. Obviously, that's happened several times over the years between the DREAM Act and other proposed reform that never leads anywhere. So again, it sounds like a great option if it happens. It seems that it's something that would be in effect where you could start gathering, working on documents, collecting your documentation, getting it all in order, that type of thing. Any news on the EB-5 reauthorization? So as of today, I'll be honest with you, this whole week my focus has not been on that because I've been working on some other cases. I don't believe we've heard anything or I've heard anything on EB-5 reauthorization or not yet. I want to say we were supposed to hear about that by the end of the month, I believe. So I have not yet, but as soon as we do, of course, you'll know. I recognize your name, so I know who's also assisting you here at the office because we've talked about your case. So I'm sure as soon as we hear something, he will let you know. So I hope that's helpful to you because I have not heard anything yet. So that's basically all that's going on right now. There's not too much else. There's some great litigation still going on. There are some excellent wins that we've received in terms of asylum seekers not being required or being a violation of their rights in order to have to wait outside the United States to seek their asylum status. So that's just a huge win, nationally for all clients and immigration attorneys alike working on cases for individuals. So, that's really about where we are right now. I don't see too many other questions. I would just say if you can, knowing that this reconciliation bill might be coming to fruition, might pass, just please work on gathering some documents, making sure that you're current on your taxes, that you've got back taxes filed if necessary, that you've got proof of your physical presence in the United States. For this reconciliation bill, generally some of the requisite dates is January 1st of 2021. So that's not too difficult. But some other components of it require proof of presence going back 3 years. Some of them require proof of, your education here in the U.S., sometimes military service, different things like that. So please just make sure, that you're keeping a hold of your immigration documents, copies of bills, proof of your presence. What I generally say as a rule of thumb is try to hang on to proof of presence documents for, each quarter of each year for at least the last 10 years, if you can. If longer, excellent. If you can get a hold of your tax transcripts because you have been filing taxes year after year, request those from the IRS. Get those in place now. Try to have as many of your documents. Make sure your passport is renewed and you've got that in your possession. Everything is taking longer right now. So you really want to make sure you have your ducks in a row as much as possible. Start working on all these things, especially because if this bill passes, and all of a sudden it opens up opportunity for tens of thousands, everybody's going to be busier, right? Everybody's going to be requesting documents, going to local consulates, requesting passport issuance, things like that. So kind of get ahead of that a little bit. Start trying to get your documents in order if you can, okay? This is something else I always love to mention each time I do a Facebook Live, as much as I can. Besides the federal court stuff and filing to litigate, if you get an improper denial, we can go to federal court and try to get that case reopened and approved. If you've got a significant delay, we can go to federal court to try to rectify that and get everything pushed through. But the other thing I always like to mention too is I can't tell you how many times I talk to families or individuals where I'm doing consultations and it appears, and they enter the United States without papers, and we think that it's likely that the individual is going to have to process for a green card outside of the United States because they've entered without papers. Sometimes they can and sometimes they can't, depending on the family relationships, meaning qualifying relatives that they may or may not have. But what's really important is to ask the question, and so all of you watching, think about this. If you're an individual who entered without papers and you're looking to see if you have status or options or an ability to apply for anything, think back and make absolutely sure that way back when, no other family members for you, meaning a parent, a grandparent, an aunt or an uncle, never ever filed a petition for you at any point in the past. Because the thing is, if a petition was ever filed where either your name was on it as the principal, what's called the principal beneficiary, meaning it was filed directly for you, or you were listed as what's called a derivative beneficiary, meaning it was filed on behalf of your parent, but you were a child at the time, and so you were automatically listed on it. Well, if you ever come across or hear word in your family that a petition like that was filed, but maybe you didn't know much about it because you were too young, never thought it would actually benefit you because it was so many years ago, well, the older it is, oftentimes that's where it leads to the possibility that it can help you. So it's really, really important to think about that if you think it's a possibility. Again, because the primary reason I'm saying this, the older the better, is because there was a law that the sunset date was April the 30th of 2001. So many family petitions were filed before that date, right? And so when they were filed before that date, lots of those folks knew that that petition may not help for a really long time, but they went ahead and filed for it anyhow. Well, those petitions now are becoming helpful because it's what allows you to be what's called grandfathered under that special law that was in effect at the time. That means that you can file for your green card in the United States without having to leave. So one, being able to file for it here, and two, in certain circumstances, when the individual does not have the proper qualifying relative to be able to file for a waiver if they had to leave, you don't have to do that. You may potentially have a pathway here. The other way that can be really beneficial, being grandfathered under that law, which is called 245I, so many of you have probably heard about it or talked about it among family or friends. The other way it can benefit is we've actually used old petitions like that, not to file a green card directly through that family member, because you may not even be to the front of the line yet, with respect to that petition, but just the date alone, the fact that it was filed and the fact that your name is on it, sometimes can lead to our ability to process for a green card for you through your employer. Based on your professional experience and your experience with that employer, or your experience doing the type of work that you've been doing for that or another employer, your background, job experience. A lot of times, if you have at least 2 years experience through another employer or job, and you're still doing that job through a new employer, you can actually sometimes go through the green card process with an employer sponsoring you if you've got the benefit of one of those really old petitions that you thought might not ever help you. So I always like to mention that, just in case maybe that's triggering something in somebody's mind. Hey, I should look into this. I should ask mom or dad or my aunt or my grandparent, because I'm pretty sure there was something. And it also comes up where people think, yeah, I'm sure that happened. I just don't have the proof. Well, that's when we also file FOIA requests, because the FOIA request can really help to dig up that information and provide proof of that. And if we can provide that proof, again, that gives us that pathway to be able to help you. And it can be life-changing, obviously, in terms of your status, thinking that you might not be able to do anything. So, that was just something else I wanted to mention in case that triggers something for somebody. So if anybody else has any questions, feel free to pop in here. I'll check it again throughout the day to see if any other questions come up. Feel free to call or email me, or call reception and schedule an appointment with me. My email address is dclaffey, so it's DCLA, F as in Frank, F as in Frank, EY @immigration.net, or give me a call, 404-949-8151. So, and I see one more question. Couldn't make it as the visas were exhausted. For DV, will I benefit from Section 2 of the bill? There's certainly a possibility that you could benefit. I can't be sure. So we have to see, like I said, just pay attention to what happens over the next week and a half or so. And if everything ends up in the bill and fingers crossed, it ends up passing, then certainly it's something that you're going to want to inquire about and see if it can benefit you. So I hope that was helpful, guys. Everybody have a great weekend, and we'll talk to you again soon. Okay. Take care. Bye-bye.